Okay, I think we'll go ahead and get started. Hi, everybody. Thanks so much for joining us, presumably from the safety of your home amidst the pandemic. My name is Alex Tinker. I'm the chair of our cannabis industry group at Tonkon Torp. I'm going to be moderating the panel today. And this is our cannabis pandemic primer. Our hope is to provide you with some practical, useful advice to help your business survive and hopefully even thrive in the time of coronavirus. We're going to have some time for Q&A, but I will note that if you've got specific questions about your business, you can always reach out to your usual Tonkon Torp lawyer. You're also welcome to follow up with any of the panelists today if you have specific questions you'd like to ask them that we aren't able to cover during the forum. We're going to hear today from 4 members of Tonkon's Cannabis Industry Group: Danica Hibpshman, Ferdie Ruplin, Jessica Morgan, and David Petersen. Before we get started, I want to pause and just talk about the format here. We are actively recording the webinar. Don't need you to sign any kind of a disclosure, and none of your private information is going to be shared, but know that if you participate in the Q&A, that your question might be recorded in association with your name. And hopefully it goes without saying, but questions asked in this format are not subject to attorney-client privilege. Feel free to submit questions in the Q&A section from your Zoom app. I'll do my best to ask the questions as they come up. We may get them in at the end. So if I don't ask your question right away, just know that it may still be coming up at the end. As you all know, the situation is so rapidly changing that we can't promise we know the answers to everything. That's always the case in the world of regulated cannabis, but is even more so now with the coronavirus impact on the economy. We'll conclude the Q&A session and we'll try to hit as many of your questions as we can. Always welcome feedback you have after the webinar. Feel free to send us comments or if there's anything else you think we ought to cover in a future one, we'd love to hear that. Finally, we can't give you legal advice on this webinar. This is just for informational purposes, and it's current as of today, April 28th, 2020. As you know, things are changing quickly. So now I'd like to turn it over to our first panelist. That'd be Danica Hibpshman. Danica recently joined Tonkon after a long stint serving as OLCC's licensing director, where she was instrumental in development and implementation of the first wave of cannabis regulations for Oregon. She advises clients on both proactive compliance and also defending against alleged OLCC violations. Danica, just to get things started, how are the issues that cannabis businesses face during the COVID crisis similar or different compared to other businesses?
Thanks, Alex. Can you hear me okay?
Yep.
Thanks everyone for being here. I hope everyone is staying healthy and safe. I think a lot of times when we talk about the cannabis industry compared to others, we really focus on the differences. And right now is the time that cannabis businesses are really in the same boat as many others. There's a lot of uncertainty in general about what the future is going to bring. That brings a lot of anxiety and inability to know how your business can grow or survive. A lot of new or increased employment type related issues as you're trying to deal with employees, keeping them safe, keeping the social distancing standards in place, and also maybe dealing with issues of employees needing to take time off that you haven't been faced. A lot of disruption in normal business practices, supply chains, contractors not being able to perform duties. All of these are things that I think the cannabis industry is facing at a much higher level than they have in the past, as are all other industries. It certainly, is something that businesses need to be paying attention to, because I think one of the unique differences the industry has right now that is a positive is that it hasn't necessarily been hit by the economic downturn yet. As probably everybody knows, retail sales of cannabis are through the roof, which is great. It's keeping those businesses doing well during this time, and also the rest of the supply chain. But I think there should be an expectation that that's not necessarily going to continue. particularly as the widespread unemployment and the effects of that increase over coming months or a year. Certainly something like cannabis and alcohol and other services may be disposable income items that are not something that have the sales level they have right now. So that's an area where the cannabis industry really has a very unique difference in that they haven't had the dramatic economic shift that so many other industries have, and they have a little bit of a preview of what could come. That really gives them an opportunity to take the steps to shore up their business practices, make sure they have all their ducks in a row and do everything they can to weather the anticipated downturn that will come at some point. That making sure that you have all your contracts in line, making sure that you understand your legal rights and obligations as you're dealing with folks, doing some business contingency planning, making sure you're following good employment practices. Those are all things that the industry really has an opportunity to do right now and really should be. And for my piece, certainly regulatory compliance. Prior to OLCC, I was a litigation attorney, and it's true for both litigation and violations. Most of them are avoidable with proper planning and following the rules. And so this is a really great opportunity to make sure your operating procedures are in line with requirements and that you're having those reviewed to make sure that you are staying up to speed on all of their current requirements. Because certainly nobody wants to get violations, but imagine what a violation could look like at a time when your business is not doing so great. Because that leads to really one of the bigger differences I think the cannabis industry has, and it's not a positive one, and that is really a lack of safety net. There is real, and Ferdie will talk about this more later, but there's no access to the federal stimulus package, and cannabis businesses, as you know, don't have access to a lot of general, the same types of capital and bank loans that other industries do. So it certainly is something that the industry needs to be paying attention to, that if and when there is an economic downturn, there won't be the same sorts of resources available to it.
You mentioned that the economic impact hasn't hit cannabis yet, or maybe at least not as much. Is that because they've been deemed essential businesses for purposes of stay-at-home orders in Oregon or elsewhere?
I think that is a little bit of a misconception that because cannabis retail businesses are open, that they are essential services, and that Governor Brown's executive order wasn't really set up that way. Retail cannabis businesses are kind of a catch-all of businesses that can remain open as long as they maintain they comply with social distancing standards. And certainly, cannabis businesses can be subject to investigation or complaints just like any other business that is open and must be maintaining those guidelines. And we did Tonkon did a webinar, I believe a couple of weeks ago, that went into this a little bit more detail in terms of what businesses in general need to be doing to make sure that they are keeping their employees safe and customers safe and maintaining those social distancing standards, and what can happen if that doesn't occur in terms of the state investigating and having potential violations. And not only could that be a violation against the business by OSHA, it could also be a violation by a city or county, or potentially even against your state cannabis license.
And Danica, have you seen any complaints filed around social distancing issues with OSHA specific to cannabis businesses at this time?
I have. So it is happening, and certainly they can take if OSHA receives their complaint and is a cannabis business, both the retail side and the non-public side, the processors, the wholesalers, the producers. Those are businesses that if they are operating, they need to be looking very carefully at Governor Brown's executive order in terms of what types of work are essential to do on site versus teleworking, and making sure that they've taken all those steps to be compliant, because they also could be forced to close or face fines if they are not complying with that.
And I'll note you brought up some employment issues, just to point out to folks that we did cover employment-specific issues for businesses a week or two back in a separate webinar that you can find on our website if you're looking for more information about how to manage employees and the issues that come up in this coronavirus situation. Danica, OLCC recently made some temporary rule changes regarding curbside sales. How does that work? What's required for retailers to take advantage of that change?
Yeah, this is a great step that the OLCC took to give cannabis businesses a little bit more flexibility in how they wanted to do their sales in this new era of social distancing. Essentially, it allows a retailer to conduct the sale within 150 feet of their premises. It is important, I think, to note, though, that this is not a mandatory requirement. This is something that a business can consider, and this is another area where there could be a lot of pitfalls that the business really needs to consider. They need to look at, whether the particular location is suited for that, whether their employees and customers can be kept safe from a liability or insurance standpoint, whether there are factors in the neighborhood that could create violations against their OLCC license. So this is certainly a great move by the state to give businesses more options for what they could do, but I certainly would encourage anybody to that is considering any retail cannabis business considering it to think it through, consult with some folks that might be able to help them think through all the pitfalls in it before they do it.
Do you think that this might provide some education to OLCC in terms of more flexible sales procedures that can still be compliant with all of the priorities around track and trace?
Yes, and I think that this is definitely an opportunity for the industry to be able to work very collaboratively with the agency in terms of different business decision options that they could take under the regulations to line it up with other industries such as alcohol sales, where curbside type delivery for beer and wine has been allowed for some time. So I think making sure that the industry is being as compliant as they can will go a long way, not only protecting themselves during this time, but also in showing the agency that they can do this in compliant ways for more long-term solutions.
And what else has OLCC done in terms of regulatory changes to adjust to the new coronavirus economy? And what else might be on the horizon in terms of regulatory adjustments?
Sure. A lot of the agency's focus has necessarily, I think, had to be alcohol in terms of a lot of the adjustments they've made. It's a very large industry that in large part was shuttered. And so I think you will see that there has not been nearly as many changes on the cannabis side as there have been in alcohol. But I think they have made some important ones, and I think that they are considering some other ones that the industry really should be looking at working with them on. First and foremost, worker permits. Worker permits, it used to be that you had to you could only hire employees that had them in hand. Now, as long as that person has an application in the OLCC system, that's sufficient. They have allowed for some elimination of minimal delivery requirements. That's an area that I think that many licensees would like to see the agency loosen up even further in terms of what home delivery options could be available. And that's something that certainly myself and others will be working to kind of formulate some ideas that we could provide to the agency in that. Curbside sales that I mentioned, they are allowing for expired Oregon ID at this time. It used to be that you could only sell to a consumer that had a valid unexpired ID, but at least for Oregon, they're allowing it to be expired at this time. Probably a big one that I think businesses really need to pay attention to and think through is they are allowing face masks to be worn by customers and employees, but the obligation to still verify that the person that you are selling to is that person and is over 21 remains. And so I think this is another area that businesses really need to pay attention to, having good staff training, having good standard operating procedures in place to ensure that if they do have customers coming into the stores wearing face masks, they can be assured that they're meeting that requirement of not engaging in a minor sale, because that could be a very serious violation that folks could face. Another big area of change that we would like to see, and there's been some indication that the agency is interested in exploring, is some loosening of some of the lender requirements, making it a little bit easier for businesses to take on new lending without pre-approval. And so that's probably going to be a longer term solution, but it's certainly something that I think would be very important to the cannabis industry, particularly if they do start to struggle, is giving as many avenues as possible to take on financing and stay afloat.
You mentioned that the economic impact hasn't been felt as much, at least by cannabis businesses yet. Is there any kind of relief in terms of tax payment being delayed or licensing fees being delayed? Any other changes for cannabis businesses in terms of when and how they need to pay money to the state?
I think this is a really important one because the answer is no. Those cannabis retail tax payments are still due. The difference is that if it is going to be payments made in cash, then pre-appointments need to be made, and there may be a little bit of delay there. But cannabis businesses need to pay those taxes, and we would anticipate the Department of Revenue will be enforcing that because that is a revenue source to the state that is desperately needed during this time.
You mentioned potential changes on the horizon to financial interest documentation and approval. And we know that we've been on a licensing pause for 2 years with a big backlog of work for OLCC staff. Is the pandemic going to change that? Should we expect further delays, time to loosen up, or something else?
I think, this is definitely going to be a little bit of an unknown for a while because, yes, the agency certainly was facing a large backlog going back several years. And I think like a lot of state agencies, they have limited resources and technology to keep up with things. And certainly it had come to somewhat of a critical juncture even before coronavirus hit, and now probably there's even that much more urgency to figure out ways to get through those backlogs and give some licensees and applicants some relief. The agency certainly had indicated a high willingness and actually had really started, I believe, to proactively look at some of their processes and see where they could streamline and do things differently to get through that before coronavirus hit. And so certainly with a little bit more urgency, hopefully that work is going to be continuing. We have heard that OLCC is planning on doing a very deep dive into their entire Division 21 rule structure over the next year or so. So there definitely should be opportunity for the agency and for industry members to come together and really collaboratively work on fixing some of these. I ate, slept, and breathed these regulations for the last 5 years, and many of them were in place from the beginning. And so the time was really coming to take that deep dive and really look at them and see what was working, what was not, what were things that could be eliminated to give businesses a little more flexibility. So I think that urgency is definitely even more so now, but every indication that the agency is open and receptive to suggestions.
Great. Thanks so much, Danica. I'll remind everyone, feel free to submit questions through the Zoom app, and we'll get to Q&A for everyone after we've gone through these presentations. Next, I'd like to introduce everyone to Ferdie Ruplin. Ferdie advises on all things hemp and CBD and has been leading Tonkon's effort to help clients access federal COVID-related relief efforts. First big question for you, Ferdie. How does the CARES Act apply to cannabis businesses, and what relief, if any, is available for cannabis businesses to access?
Thanks, Alex. I think the key thing to remember is that hemp businesses that are compliant with federal and state law are eligible for CARES Act loans, but unfortunately, as Danica mentioned before, marijuana businesses are not eligible. So the two primary loan programs under the CARES Act are the Paycheck Protection Program and the Economic Injury Disaster Loan Program, both of which are governed by the SBA, the Small Business Administration, and are governed by existing guidance and regulation by the SBA. And unfortunately, the SBA is prohibited from lending not only to quote unquote direct marijuana businesses like producers, processors, and retailers, but they're also prohibited from lending to indirect marijuana businesses, which is broadly defined as any business that generates any revenue from a direct marijuana business.
And I suppose in today's economy, almost every business derives at least a little bit of revenue from a direct marijuana business. Are there any clear lines that SBA has offered for businesses that think they may or may not be an indirect marijuana business in assessing whether they can apply for this kind of assistance?
Yeah, unfortunately, the SBA guidance on this is pretty limited. You know, they say that companies like testing services companies and companies that sell grow lights and other equipment to marijuana companies are deemed to be indirect marijuana businesses, but they don't really provide any revenue thresholds or any bright line metrics to determine whether or not you've done enough business with a marijuana company to be deemed an indirect marijuana business. But the practical reality of, if, when, and how the SBA will take a closer look at these loan applications to determine whether or not borrowers, have been conducting business with marijuana businesses really remains unclear, and I think probably is not likely. There's been a lot of media coverage lately about, a lot of folks are enraged about bigger public companies like Shake Shack and Potbelly that have taken advantage of the loan programs while the smaller businesses are getting pushed out. So there seems to be a lot of focus on that. And I think the Treasury and the SBA will be focused on enforcing and preventing companies like that from receiving the loans. But it doesn't seem to be a priority right now to look at whether companies that have engaged with marijuana businesses to be prevented from getting these loans.
Is there any reason a business, an ancillary business that isn't sure whether it would be treated as an indirect marijuana business shouldn't give it a shot and apply for the loans if they otherwise qualify?
Yeah, it's a tough question because you have to make a certification on the loan application that you are in fact eligible. So, it's just a question of whether you or not you want to take the risk. The SBA has been completely overwhelmed with the number of loan applications that they've received thus far. There were reports yesterday that the online portal was crashing, and to give some perspective on this, in the entire 2019 year, the SBA approved a little under 52,000 loans with a total value of about 23 billion. And just over the past few weeks, they've processed over 1.1 million loans. And, they went through the entire $350 billion funding allocation from Congress in less than 2 weeks. So the SBA is completely swamped and overwhelmed, and it doesn't seem like they'll really have the resources and the infrastructure to go through and take a closer look at these loan applications.
Any tips or guidance for hemp businesses or others that have managed to secure the Paycheck Protection Program loans?
Yes, so if you've received a PPP loan or you've been approved for one, the key right now is to really focus on the loan forgiveness application. And as a quick reminder, loan forgiveness is available for costs incurred and payments made on payroll costs, rent, and utilities in the 8-week period following the date that the loan funds are dispersed. So with that in mind, we've put together a handful of helpful tips. I know our team did a webinar last Thursday that highlighted a lot of these tips and also went into kind of greater detail on the PPP loan program. But just to reiterate some of those practical tips, number one, you should definitely designate a point person within your organization to handle the loan funds and the payments and the loan forgiveness application. You need to make sure you're getting organized right now and that the person running point on this is knowledgeable about the loan forgiveness requirements so that they can effectively handle that process. Number two, if you can, you should try and segregate the loan funds in a different account just so it's easier to make sure you're keeping track of it. You definitely want to keep receipts and documentation for all expenses that are paid with the loan funds, because when it comes time to apply for forgiveness, you're going to have to provide all of that backup documentation to the lender. Number three, as a quick reminder, with respect to the amount of loan forgiveness, 75% of that amount has to be attributed to payroll costs, and only 25% can be attributed to other expenses like rent and utilities. So you really want to maximize the amount that you're allocating towards payroll so that you can get a greater amount of forgiveness for rent and utilities. And the last tip that I will say is that it's really important to keep in mind that the SBA has promised that it will come out with additional guidance on the loan forgiveness provisions. There's a lot of questions that remain unanswered at this point, and a lot of different lenders are interpreting the statute and the guidance differently. So it's important to be in close contact with your lender and make sure you're on the same page when it comes time to file that application for loan forgiveness.
Other than the loan programs, are there any other sources of relief for cannabis businesses coming from the CARES Act?
Sure. So there's a couple of provisions that provide tax benefits. There's an employee retention tax credit, which provides employers with a refundable payroll tax credit for 50% of the wages and health insurance that are paid between March 13th of this year through the end of the year. And there's also a deferment plan. Employers can defer paying their FICA payroll taxes for the remainder of the year. So many commentators in the industry have said that these tax benefits are available for cannabis businesses because they fall outside the realm of Section 280E. But I definitely recommend that you reach out to one of our tax attorneys or your CPA to confirm whether taking advantage of those benefits makes sense for you.
Any financial assistance coming at the state level?
Yeah, unfortunately, at this point, all of the state level funding programs that I have seen are either tied to federal funding or have their own internal prohibitions against lending to cannabis businesses. I know that a lot of state legislators and federal legislators are working together and trying to bring some opportunities for cannabis businesses to get them the financial relief that they need as a result of the COVID crisis. I know there's been letters that have been written to Congress, and so I remain hopeful. And there's going to be most likely additional rounds of funding for the Paycheck Protection Program. So it's just important for businesses to keep their eyes peeled and be on the lookout for additional programs that might become available.
Thanks, Ferdie. Next, I'd like to introduce Jessica Morgan. Jessica is co-chair of Tonkon Torp's Financial Services Group, and she advises cannabis clients on securities offerings, private funds, and other fundraising, and also the regulatory aspects of M&A transactions for cannabis-related businesses. Jessica, what are the specific COVID issues that are facing cannabis businesses looking at potential mergers, acquisitions, and other business combination transactions?
Thanks, Alex. Hello, everybody. I'm guessing you can hear me. First, it's important to know what contracts and activities of your business are being affected by the pandemic and to review those agreements carefully to understand performance obligations. For cannabis businesses and non-cannabis businesses and their ongoing contracts, we recommend that businesses review their contracts to determine whether there are potential outs for continued performance. Usually this means that the contract would contain some sort of force majeure language that's not even required in order to excuse performance. For instance, there's many other legal principles that can apply in situations such as these to help businesses that are operating in good faith to reduce their hardships. In fact, Tonkon has issued several pieces of guidance on this, and I believe it's available on our website if anybody wants additional information. Now, specifically for businesses engaging in M&A transactions or securities financings, you should expect more due diligence requests from buyers and investors. Usually this would concern inventory confirmations, material contract reviews would be more extensive, looking into IT systems, employment claims, layoffs, and then business continuity insurance. In purchase agreements themselves, you should expect to address issues like valuation issues that would affect the purchase price, potential for earnouts to adjust for this. MAC clauses, definitions would include pandemics and public health emergencies, additional representations and warranties to cover any of the issues that we're dealing with right now, interim operating covenants, which would give the seller the ability to take emergency actions prior to closing. And with cannabis businesses, this is specifically an issue because once you do complete the transaction documents, there's a significant time period before the actual closing of the transaction. And that would be something that cannabis businesses need to pay attention to so that they can continue to operate their businesses. Financing issues for the buyer are going to become a problem, and indemnification for specific COVID-19 related losses. In financing documents, your risk factors are going to need to get revised to include specific pandemic-related risks of losses. But really, in any business transaction, parties should expect that the transactions will be delayed due to logistical issues with social distancing restrictions. Most buyers and investors want to ensure that operating businesses are as they are represented, and transactions will likely be contingent upon the completion of physical inspections. Now, I'm not addressing anything with publicly traded companies. There's a whole set of complexities associated with those. We do have a lot of familiarity with those issues in our office, and happy to talk about those if anybody wants to. But reminder that if anyone is making any changes to their organization for either M&A or equity investments, that they need to make sure to check and make sure that OLCC approval is either not necessary or is obtained. And I know that the timeline for that is significant right now, but it's still really important.
And has your team in the M&A group seen the impact of COVID on pending transactions, both in the cannabis space and just generally yet, or is it still to come?
I think some of the larger transactions have slowed down a little. There still seems to be a lot of movement with license transfers or sales of businesses related to licenses that are much smaller. But I haven't seen any slowdown in that area yet.
What can cannabis businesses do right now to maintain sales, to keep the business in that condition that the buyer wanted to buy it in amidst the COVID crisis?
Well, like Danica mentioned earlier, sales are currently doing pretty well for cannabis businesses, but as you know, as we all are aware, things change rapidly. The COVID-19 pandemic has caused significant disruptions to businesses, supply chains in other industries, and what we're advising them is that they should carefully consider the effects of the crisis on their supply chains to identify existing or potential problems. And during this review, businesses should be thinking about diversifying their supply chains as much as possible. I'd also suggest that businesses with insurance contact their brokers and determine if their policies include coverage for business interruptions or pandemic-related losses. Policies may cover things like physical loss or damage to the property, if there's contamination issues. There could be supply chain coverage and just general liability insurance. In addition to your own policies, you should confirm whether or not you're an additional insured on any contracts with third-party vendors. And the last thing I'll mention is that with cannabis retail businesses, to focus on their online presence and develop online relationships with customers and general online sales while most of the country is shut down. And in the event that delivery business is an option, then businesses should consider adding that to their current activities and add into additional channels.
Thank you. I want to turn now to Dave Petersen. Dave is chair of our real estate and land use group at Tonkon, where he helps cannabis tenants and landlords negotiate commercial leases, navigate land use issues, and a lot more recently, address what to do about tenants' inability to pay because of the pandemic. Dave, first question, we've heard a lot in the news about rent relief for commercial tenants, maybe even eviction moratorias for non-payment. How does that apply to cannabis tenants? Can they take advantage of those protections?
Yes, thank you, Alex. So the Governor Brown's order, number 20-13, which was issued on April 1st, extended both rent deferral and eviction protection to commercial tenants. The order allows commercial tenants to defer the payment of rent and other service charges and fees, which includes late fees, until the 1st of July. It's not clear whether the governor's order applies to interest accrued on unpaid rent. And what's most important is that the order applies only to the non-payment of rent. A tenant, the commercial tenant that doesn't pay the rent between now and July 1st cannot be evicted and cannot have their lease terminated for non-payment. However, any other kind of default under the lease still could be the basis for action by the landlord. Now, practically speaking, could a landlord seeking to take advantage of that provision actually get some relief in the form of a court order or a sheriff to actually do an eviction is questionable in light of problems with courthouse access and social distancing. But the landlord could still terminate the lease, notwithstanding that they couldn't get any action on it until later. So it's important to understand that while the order does offer the opportunity to not pay the rent, it doesn't offer the opportunity to breach the lease in other ways. Alex?
And so it sounds like those provisions are a rare thing that does actually potentially benefit cannabis businesses just like any other. Is that protection automatic, or do tenants need to do anything proactively to benefit from that order and the provisions of it?
No, tenants do need to act proactively in a number of ways. First of all, the non-payment of rent is excused only if the inability to pay is a result of the pandemic. So to compare, for example, let's say a business suffered a fire and was unable to open for business because of that. The governor's order would not excuse non-payment of rent in that situation. There may be other provisions in the lease that may excuse it. It wouldn't come within the scope of the order. The burden is on the tenant to document a causal chain between the pandemic and the loss of income and the inability to pay rent. And it has to provide that documentation to the landlord within 30 days after the rent is due. Now, what's not clear if that means 30 days after the rent was otherwise due, or if it means 30 days after July 1st. So for example, if the rent was not paid on April 1st, it's entirely possible that the documentation requirement would require compliance within the next 2 days for purposes of sharing information with the landlord. Also, tenants are obligated to pay the rent to the extent they can do so. We heard from both Jessica and Danica that right now the cannabis retail business is booming, so it might be rather difficult to demonstrate with evidence a loss of income related to the pandemic, but I'm sure it's possible, and I'm sure the situation can change. It's certainly too early in the new environment to have any court decisions or other evidence on which to base a conclusion as to what this means specifically in terms of what kind of documentation you have to provide. I think likely a record of your sales that shows some sort of drop off in sales sometime after mid-March would probably suffice.
And just to be clear, does this order mean you don't ever have to pay that rent, or it's just deferred?
No, the rent is deferred, and unless the order is not forgiven, unless the landlord agrees otherwise, or unless the governor modifies her order in some fashion, the rent and the charges are due in a lump sum on the 1st of July.
And in practice, how are these issues being addressed between landlords and tenants in the marketplace?
So it's still early, of course, but what we are seeing, not just for cannabis businesses, but commercial tenants in general, is generally a spirit of cooperation and shared sacrifice and recognition that landlords and tenants' interests are aligned here. And most, if not all, landlords are are agreeing to voluntary rent release rather than relying solely on the order. Now, if this goes on and landlords are not bringing in rent and they're going to not be able to make payments on their mortgages and their banks start showing an interest in the fact that they're not paying their mortgages, things could change. Certainly right now, there's a spirit of cooperation. For businesses that can remain open, like cannabis businesses, landlords are generally agreeing to a rent deferral, much like the order, and a waiver of late fees. We're not seeing abatement or forgiveness of rent. That's much more common in situations like tenants that can't be open at all, like hair salons and health clubs. In those situations, some landlords are agreeing to actually forgive the rent and just add extra time on to the end of the lease term to compensate. Recognizing that a lump sum to come due on July 1st or some other agreed date could be difficult, many landlords are agreeing to spread out.
Did we lose Dave?
Certain tenants are not able to know what other deals other tenants are getting. I hope you guys are able to hear me because I just got a note that says my internet connection is unstable.
You're back now.
Okay. I was saying confidentiality provisions are common in lease amendments. Also, landlords are obligating tenants to apply for available relief. That may not apply quite so much for the cannabis businesses, but certainly for hemp businesses. You know, the landlords want tenants to take the maximum advantage available to them from the government relief programs that are being provided. One thing for tenants should watch out for is obligations in other documents they may have signed at the time of leasing that would prohibit an amendment to the lease without a lender's consent. So for example, a common document that's signed is a subordination and non-disturbance agreement where a tenant agrees that their lease is subordinate to the landlord's mortgage. And you should be careful as a tenant to agree to a lease amendment without the lender's consent if in fact you had previously promised that you wouldn't do that without the lender's consent. In the short term, that might not be so much of a risk for the tenant, it's more of a risk for the landlord. But in the longer term, tenants don't want to force their landlords into default under their mortgage because that could be bad for the tenant as well.
And setting aside any specific executive orders, are there other ways that the pandemic may excuse or justify delay in payment of rent or other tenant obligations under a lease?
Potentially. This is what's known as force majeure, which is a provision that appears in many agreements of all sorts and is generally a laundry list of unusual or unforeseeable events that can excuse or justify the delay in performance of a contract. Many leases have force majeure clauses. Also, many leases, however, specifically exclude from the applicability of those clauses the payment of rent. So the takeaway from this is to not necessarily assume that the pandemic constitutes a force majeure under your lease, which may justify either non-performance or delay. You're going to have to read your lease closely for two things. First, you're going to have to determine if a pandemic is in fact listed as a force majeure. Most agreements don't list pandemics as force majeures. There's also quite often, however, some sort of catch-all clause that says something like unforeseeable events beyond the reasonable control of the parties. You might be able to argue that a pandemic fits within the catch-all. Also, consequences of the pandemic might qualify. A common force majeure event is a government order that makes performance more difficult. Certainly, maybe not for cannabis businesses right now, but I suppose even the social distancing act.
I think we've fallen victim to David's weak internet connection again.
read your lease and see what it says, because everyone is different.
Dave, we lost your last couple of sentences. Could you repeat for us now that your connection's back?
Sure. What I just reiterated that the takeaway on force majeure is to not assume that the pandemic is a force majeure, but to read your lease and try to fit the facts to the wording in your document.
Thank you, David. We're going to open it up for questions now. I think everything that's been submitted in writing so far has been addressed. Feel free to submit questions through the Zoom app's Q&A function. While we're waiting for you to do that, I might just put Danica on the spot. Danica, any crystal ball forecast as to potential adjustments to the OLCC's regulatory regime on cannabis that we might see in the sort of second phase of Oregon's industry?
And it may look like my screen is frozen, but I got you on audio here. No real crystal ball. I am encouraged by the idea that they are considering doing a full review of the entire Division 25 regulatory structure. I think that is a really important thing that they need to do in order to be able to actually provide some relief to the industry, both in the short term and potentially in the long term, in terms of figuring out what areas are needed for the immediate, to deal with the immediate pandemic issues versus something that is long term, something that could be a business decision. What I'm really hoping more than anything is that the agency really is able to delve into some of its technology and processes, even aside from its rules. And that includes metric and their licensing system. Those are areas that are a big struggle for licensees and attorneys and consultants that are working with them. And so when I was there, I certainly knew that it made it difficult to adjust rules when you don't have the technology to meet the standards. So I'm hopeful that perhaps in this pandemic, that's kind of a twofold process that could be going on, is both developing rules that fit with better business practices, but also the tools and technology to make those things happen.
Thanks, Danica. I'll open it up one more time for questions. We do have everyone here for a little while longer if anyone has got specific questions they'd like to get a hot take on from any of the panelists. Otherwise, you've got everyone's contact information there on the screen, and you can find us all at www.tonkon.com, where we've also posted a number of other resources relevant to businesses dealing with the COVID crisis, including the force majeure content and the employment matters content that David and Ferdie mentioned. It looks like we have cleared all the questions at this point. So with that, I'll say thanks to everybody for joining us, and thanks to our panelists. Please don't hesitate to reach out to any of the folks on the panel or your usual Tonkon Torp lawyer if you've got any issues you're facing that you could use help with. Thanks again, everybody, and we'll see you next time.